where he leads the employment and labor law group of the firm. Prior to founding E2R and the law firm, Stuart practiced for many years with one of Canada's largest and most prestigious Canadian law firms. Stuart is one of only a small group of employment and labor lawyers certified by the Human Resources Professionals Association as a certified human resources leader. Stuart has advised corporate employers on all matters pertaining to employment law, labor relations, and human rights law. He has appeared before the courts as counsel on behalf of a wide variety of corporate clients, as well as administrative tribunals. Stuart counsels employers with respect to the employment impact of commercial transactions, including mergers and acquisitions, the negotiation of employment contracts, wrongful dismissal litigation, injunction applications, occupational health and safety, employment standards, workers' compensation, and human resources communications and strategy. Stuart provides ongoing advice to some of Canada's leading public companies and is often consulted by major Canadian media outlets to provide information and insight in employment law and human resources matters. As a dynamic and down-to-earth speaker, Stuart is regularly requested to speak to employee and managerial groups, as well as industry associations. He is also a regular contributing author on human resources and legal matters. Recently, Stuart has combined his affinity for comedy and all things HR by producing HR in a Car videos for the business community. Stuart is actively involved in the community and sits on the HR committee of a major Toronto area not-for-profit, which helps people find work from all walks of life. Please join me in welcoming Stuart Ducoffe.
Thanks, Dave. I had no idea it was going to be that lengthy an introduction. I started falling asleep. Okay. So let me start with, so I have a 9-year-old son. When he was 7, of course, he doesn't like school. He still doesn't like school. Preferred not to be there. So he has the opportunity, because he's not feeling well, he says, oh man, I'm going to take this opportunity to extend my non-attendance at school. So I said to him, I said, you know, you look fine to me. Why can't you go to school? Now look at our topic, health and safety considerations. He has no idea basically what I do for a living, for the most part. He looks at me and he goes, Dad, with learning, there are learning hazards. I shouldn't be there because school has learning hazards. And I went, there are hazards everywhere now. So in my employment and labor work, and we're talking about health and safety hazards, my own son with school, apparently learning hazards exist at school. So it's omnipotent, and so we have to pay attention. All right. What's our agenda? Remote work policy considerations. There's not, I'm sure everyone in your individual organizations is dealing with remote work, right? It's the new reality. It's even the new reality in negotiations with employees, if you can find them, right? We're going to talk briefly about remote work tax considerations. I am not a tax lawyer. If somebody asks a question, I'm going to duck, I'm going to weave, I'm going to hide, but I can tell you something that is interesting to note. So that's why we're going to draw it to your attention. Remote work agreement considerations. If we're going to have remote work with our individual employees or certain groups of employees, we may want to incorporate language in an agreement. Is it just a free-for-all? No, we want to identify the confines, the limitations, the parameters of what that remote work is. Remote work, telecommunication, contractual policy term. So we're actually going to go through a term. We'll have an example and give you, some insight into what certainly one organization has done vis-a-vis their policy. Opportunity for a new employment agreement. Who remembers the show, Let's Make a Deal? I don't know if it's still on, Let's Make a Deal. But this gives you the opportunity to make a deal. Why? Because an employee, you're offering an employee something of value they didn't formally have. All right, as the employer, what I want in exchange? I want to cut a new deal. Right? So it's an opportunity. Remote work health and safety considerations. Save and except for a unique provision that we'll speak to just very briefly in Ontario. Essentially, the workplace extends to the home environment. So an employer has onerous occupational health and safety obligations vis-a-vis the workplace, right? We all agree on that, we all note that. but it extends, in all likelihood, to home. We're going to talk about remote work and workers' comp. Some of you may have been aware of an Air Canada decision. That's what we're going to talk about. It's kind of mind-blowing as it relates to an injury that occurred at lunch in her home. Okay, as we go through, if you have questions, don't hesitate, fire away, yell at me. Just if you're going to throw something, give me advance warning. That's all I ask. All right, policy considerations. We're going to have a remote work policy. Well, what should be in it? Duration. Well, are we piloting this? Is it temporary? Are we making it long-term? What are we setting as expectations? So from a policy perspective, it's important to identify how are we approaching our remote work? Right? And you've heard this before, you don't need to hear it from me. To develop positive employee relations, what do you need to do? Communicate, communicate, and communicate. So if I don't communicate properly what I'm expecting as an employer as it relates to our remote work policy, then there might be inconsistencies and misunderstandings. Scope. Who does it apply to? Everyone? Now, that doesn't come without some problems, right? One group you allow, one group you don't allow. The perception of the group that you don't allow, if they believe they can be successful in accomplishing their job tasks remotely, and often this happens now, during COVID they did, so now they're saying, well, what? Why can't I continue to do that? Well, because it's not as efficient. But what? I would think I was successful. I think I was good. I think we as a group who worked in that particular classification, as it were successful. So you have to be mindful of that as well. Equipment, of course. They're working remotely. You have to make sure they have the appropriate equipment. But of course, sometimes what's the question? Who pays? Right? Who pays for all the equipment? That can be sometimes a question. Okay, the health and safety audit of the remote work environment. And we're going to talk about workers' comp in a bit. So if it is the workplace, and you're supposed to conduct hazard assessments, as opposed to school learning hazard assessments, you're supposed to conduct learning assessments, occupational health and safety hazard assessments. Well, what about the home, if that's the workplace? We're going to talk about Air Canada and what happened to Air Canada. So we have to start thinking, what are we going to do? If we have that legal obligation and somebody's working remotely, how do we potentially comply with that obligation? Location. This is happening, and I'm sure some of you will start smiling. All of a sudden you learn Joe is in Panama. Joe's where? He's in Panama. What's he doing in Panama? Well, he was working remotely. He figured he'd go to Panama. So you better figure out if there are going to be limitations on where somebody can work and for how long. Not to mention the other legal obligations that could arise because you've allowed somebody to work internationally. Could be tax issues, immigration, right? In the local host country that obviously the employer may have responsibility for. So, and there have been a lot of employers that have been caught by that. You know, they used to send postcards. That would be the coolest thing. Joe sends the postcard. It's wonderful here in Panama, right? And here's the big one. In any policy, you reserve the right to walk it back, change it, revise it. Fulsome, 100% discretion. Because if you don't, what's the employee going to argue? The employee will argue, you've impliedly, by letting me work, you've acquiesced in letting me work remotely. What have you done? You've amended my employment agreement. That's what you've done. So it's a new term of my employment agreement that permits me to work remotely, and if you change it, what does it mean? I guarantee there's probably less than 3 of you that in this room that have never heard the expression constructive dismissal. Right? You fundamentally changed my deal. You told me I can't work remotely anymore. You never put a reservation on that policy. So I say, you've constructively dismissed me if you force me to come in there. And by the way, what does constructive dismissal means? Pay me my severance, as though you terminated me. So there you were, being very accommodating, permitting the employee to work remotely, good faith, great people we have on board, and then you have that singular pain in the body part that we all know, right? Okay, this is where I get nervous. I'll stand behind the screen. All right, but this is something you should note. People are, so let's go to the second bullet, where an employee works from home outside the province where the employer operates. What does it mean? That home office could create a permanent establishment. Well, if it's a permanent establishment for tax purposes, then the company now has to pay provincial corporate tax. So you've recruited somebody in Saskatchewan, you're Vancouver-based. Is it possible that now you've created a permanent establishment? And now you have corporate tax. Something your controller would go, what? What do you... Now, it's typically, a P for provincial tax purposes includes a fixed place of business. A home office is not normally. Okay, so I got you nervous, and then I'm walking it back. Considered a fixed place of business, provided the home office is not under the control of the employer and is not objectively identified with the business of the corp. So if you're advertising it, as it were, potentially could be a permanent establishment, a fixed place of business. So in the absence of the existence of a fixed place of business, the PE may nevertheless exist if the remote employee has general authority to contract. So if you're giving that employee general authority to contract, then it's possible. It's now a PE. Briefly stated, though, courts typically, in most situations we're seeing salespeople, and so typically the courts won't apply it to salespeople, but if that person can bind the corporation without prior approval. So if you put somebody there, and you see the last sentence says senior management. So let's just use that example. You put a senior management person there who does have the authority to contract on behalf of the organization. Then you run a risk, it's a PE. So if you're going to have somebody working in a home office in another jurisdiction, then you want to be mindful of what their responsibilities are, or at least speak to your tax guys, right? At least raise it. By the way, just an aside, we get clients that are asking all the time about, okay, we have an employee that wants to work internationally. Is it complicated? And we go, yeah, it is actually. Yeah, so you can't just do it. Okay? Okay, remote work agreement considerations. Okay, so if we're going to have an agreement, it should address these considerations. Duration, once again, like the policy, how long? Do we want it for a short period? Pilot project, how are we explaining it? So that it's well understood. Location. Joe, you can't go to Panama. Acceptable locations where you can work. Okay, so everything's clear. This you certainly wouldn't not expect it. Reporting requirements, right? What are we going to do? Somebody's working remotely, mandatory meetings, logging in, all that nice stuff. Equipment, expenses, time and attention when you should be online, right? And that's sometimes, obviously, one of the benefits, of course, of working remotely, as we all know, is that idea of attending to personal issues, right? But those personal issues can sometimes overlap what was understood to be the business hours. And there's no more frustrated a manager than a manager trying to get in touch with their remote employee. And that remote employee is currently unavailable, and you're waiting for that return email. Right? Just whistling at where is he or she? So you want to set that out. And, no surprise, reserve the right. Reserve the right to modify it, cancel it in its entirety. You could have, now typically you're going to have notice. So if I'm permitting somebody to work remotely, I'm typically going to incorporate a notice to discontinue it. Otherwise, there's an unfairness attached to that, right? Okay, now, given the likelihood of ongoing changes to the remote work strategy, you may want to think of a hybrid approach, incorporating contractual and policy language. Because if it's going to evolve, often you put it in a policy, it's easier. Because contractually it gets kind of cumbersome. Change the contract every time, change the contract. Here's the addendum, here's an addendum, sign it. No. So you may want to just incorporate it as part of a policy. So here's an example, right? Contractual provision. You must adhere to the company's remote work telecommuting policy as set out in the handbook at all times. Attached to Schedule A, you'll find the copy. Please read the policy and ask any pertinent questions before signing and returning this offer. Okay? This particular one speaks to relocation expenses. We will not reimburse any relocation expenses and home office expenses, including cost of internet, office supplies, etc. Now, please note that while we anticipate having you work remotely on an, if applicable, indefinite, but whatever the basis is, the decision to allow for remote work is in the sole discretion of the company. The decision to allow you to work remotely can be discontinued at any time for any reason without notice. Now that's tough, but you can still give notice, but you're setting it out on a without notice basis. And should the company elect to revoke the privilege, guess what it will not be? It will not be deemed to be a fundamental change to the employment relationship, nor shall the change constitute a termination or a constructive dismissal. Getting back to what I said earlier. We're permitting you to do it, but we're telling you that if we revoke it or change it, it doesn't constitute a constructive dismissal. You can't claim that by virtue of that fundamental alteration, the revocation of the remote work, that you're entitled to severance. Yeah?
For a set pattern, do you have to give them some sort of consideration for this to be binding?
If you've already set the pattern, that's the question. So you have to give them what's often called legal consideration. Boy, here's a legal answer. It depends, right? Yes, you're right. A practice can ultimately establish that implied term, right, depending on how you've shaped that practice. But, if after the first month we were to do it and you were to identify to the employees, hey, we're reserving the right to discontinue it, you're probably going to be okay, right? But if it's 6 months, 8 months, 10 months down the road where you've permitted remote work, and then all of a sudden you say, oh, by the way, we reserve the right, that may be a challenge because through that period of time, you've established that new term. So getting back then to legal consideration, how does that work? Anytime you change a contract, you always have the ability as an employer to say, hey, listen, here's your new contract or a new term. In exchange for that, we're going to give you something of value. Right? So what's the most common? Money and a termination provision, right? Here's the new employment agreement. It incorporates a termination provision limiting entitlement to minimum standards. Here it is. Voluntarily enter into it. I'll give you money. You don't want to do it? I don't give you the money. So yes, you could ultimately, if you were concerned about the situation, could try to do that, but it has to be voluntary. Has to be voluntary. The employee can say no. If the employee says no, status quo. For that employee, anyways. Yeah?
So the question is probably along these lines. So we've gone through COVID. We've enforced, in some cases, not forced, but we've proven based on the epidemic, where do we sit as an employer right now? And what is the current court's feeling about that?
Well, I don't think you,
Get to that, but
yeah.
that's a question that keeps right in my mind.
And you're absolutely right. So what's the employee claim? You've allowed me to do it for 2 years. I've arranged my life because you've allowed me to do that. And now you're telling me you're going to take it away? That is absolutely a fundamental change to my deal. Employer response, when did I tell you this was permanent? Did I say anything to you like that? Did I put it in writing? Did I even tell you verbally that this was an indefinite duration, this remote working? No, I never said that to you. I never made a representation that you could interpret in any way as an amendment to your deal, incorporating this privilege now.
So what's reality now? What's happening?
Well, I think we don't have any definitive word from the courts.
Got to give the court precedent to you have one left or right here?
Well, in Ontario, you have the infectious disease emergency leave. So for those of you who know that in Ontario, what that meant is statutorily, an employer could say to an employee, I'm reducing your hours by 50%, or you don't even work at all. And it's not a constructive dismissal from a statutory perspective. But the courts, save and except for one court, has said that's a constructive dismissal from a common law perspective. Okay, so now on this issue though, on this particular issue, it hasn't been litigated, but I think it's difficult for an employee to lay claim that the employer, in response to an extraordinary circumstance, the pandemic, and by the way, in some places, you couldn't attend at work, right? Right? Ontario being an example, you couldn't attend at work. There were periods where you had to work remotely. You couldn't basically almost go on the streets, right? We all remember that. And so the employer responds to an extraordinary, unique scenario, the pandemic, responds to governmental initiatives and legislative initiatives that say stay home. And that constitutes a representation by the employer to change the terms of the employee's employment agreement. That's a hard argument to make. But it depends on what the employer said. And a lot of people, management representatives, will sometimes make statements in the best interest they think of good relations. They'll make those statements, and those statements then will be characterized by the employee as, aha, you can bind the corporation by virtue of what you said. Now, that's going to be specific situation based as to whether that's accurate or not. So I think the short answer to your question is, I think the more difficult argument is the employee argument that says just because it's been 2 years during the pandemic and I was allowed to work remotely, that you cannot now require a reversion back to the home office. I think that's a tougher argument. Not to say you can't make it, but I think it's the tougher argument. But as we move away from, right, the sensitive time of COVID, as we're now out of it, well, if the employer keeps leaving it there, the remote work, and leaving it there, month after month, now the argument's more favorable to the employee. Yeah?
So, granted you don't have a crystal ball.
Hold it. Get my...
Do you think that rulings in the courts are going to be brought down to precedents on this in past cases, or do you think that there's going to be amendments to acts and legislation going forward?
You will not have a legislative initiative as it relates to the legal principle of constructive dismissal. I don't think you're going to have that. So, and there is no precedent for this kind of situation, but you have the application of the legal principle. And the legal principle of constructive dismissal is you've repudiated, what's called you've breached, a fundamental term of my employment relationship. Now, without notice is technically what it is, but let's, for these purposes, leave it at that. So that's what it is, a fundamental change to a fundamental term. Okay, so working remotely for 2 years, you can understand why the employee would characterize the reversion back to the home office, as it were, as a change to a fundamental term. But once again, from the employer perspective, where did we change that term? We allowed you during an extraordinary circumstance. But as now that circumstance wanes, and that's why it's important to act soon. The longer you wait now, in light of current circumstances, the more risk you're incurring. Yeah?
What happens if you mandate employees back to the office and the employee comes back to the office for 8 months?
Then at that point, they decide, you know what, I like working from home. So they want to go back. So the employer says, no, you can't go back. You have to live here. At what point does the contract, because the contract changes, right? Your employment contract changes when you're working from home, and the employer can be liable for that from being constructive dismissal, right?
Right, but what, in that circumstance, if the employee has come back to work, now, there's a lot of factual circumstances that would come into play there, but certainly the employee is conceding, subject to representations that are made at the time, is conceding that, in effect, he or she has to come back to the office when asked. So to now take the position after a month, using your example, oh, I don't have to come back to the office. Well, you've already acceded to that. You, the employer argument, would say, well, you've already acknowledged that you had an obligation and you did come back, right? So I'm sorry if you have to continue to attend.
It's a better situation for the employee.
Yes, yes, it's a more favorable situation. Yeah.
We're probably all facing more is the younger generation looking for that flexibility. And also, there are certain jobs that don't mix well with the remote situation, and others that do. And so there's probably going to be a hybrid here. And then, you're getting into some of these things that we talked about earlier. How do we start limiting our liability as companies when shaping these ideas? And I know we're all in new territory to a certain extent. In other ways, but for us, some people, I don't need them back in the office, and they seem to be quite productive at home.
Great.
And they're happy, so I get their loyalty and whatnot. If I were to force them back to the office, who knows what would happen? And then, can we limit the WCD, let's say, workplace to their office alone, or just the extent to their toilet and their kitchen and their...
Well, we'll talk about that shortly, but on the issue of the generational, where's Daniel? Where is he? We had a long discussion last night, and he was telling us about letters of the alphabet, generation Z, double Z, triple. He seems to have a finger on the pulse of that. But what was, and look, we see this, but it just pointing out we had an interesting discussion last night. It's brutal, right? And you sit on both sides. So to have the management perspective that we need to do what we need to do to get it done, and we're more productive, but yet, good luck with that attitude if you can't get the younger generations to buy in. If they're not going to buy in, right? If you can't beat them, join them. Right? So yes, it is tough. So you have to build in. So what do most organizations do, right? Most are doing hybrid. Use an example, right? Sometimes in the office, sometimes out. Right? Some kind of scheduled hybrid model. Okay? So it's trying to walk the middle line. Right? But you may, and as Daniel was saying last night, good luck trying to get some people. They want 100% remote. They want to be paid as though they live in downtown Toronto at King and Bay, right? Even though they're 600 miles away, right? And, the expectation is so high. And for those that have paid their dues, it's like, okay, I better walk, I better breathe, right? I got to breathe, right? Yeah?
When does reasonable accommodation go down the path of, well, now you just have to acquiesce? For example, if you have some kind of policy, and you've got one of your workers that says, well, you know, I have a personal situation, I can't come into work today, but I could work from home, you know, on that particular day, because, you know, you do let me on another day work from home.
It's a good question.
Say, well, you know, I need the man hours, so yeah, I'll let you, you know, as a reasonable accommodation for your personal situation, work from home on this unusual day. When does that become dangerous?
Right.
You know, what kind of a slippery slope is that?
So in order to legally oblige the employer to accommodate, it has to be a prohibited ground of discrimination under human rights legislation. So sure, I can beg for the employer to permit me, because I have to deal with, you know, cleaning my cleats for soccer, right? So sure, I can, but if it's not related to a prohibited ground of discrimination, then I don't have the obligation to accommodate. But if you say, for example, childcare or some kind of medical, obviously, issue, then that triggers the legal obligation to accommodate up to undue hardship. So the enterprising employees, I just gave them an incredible compliment, the enterprising employees, I really don't feel that way about them, but the enterprising employee is going to shape the story so that it fits the Human Rights Code prohibited ground discrimination. Put it somewhere in that category. Find one of the prohibited grounds and try to shape it in that, and that say to the employer, you have to accommodate me. And typically, it's something to do with family, right? Or obviously medical. That's like, you know how many medical notes come in? Oh, my client. My patient has to work remotely. What? What do you mean your patient has to work remotely? And by the way, that's all you get sometimes, right? So, and then you have to clearly make further inquiries in those situations. So yes, it is possible, but you've got to tie it. You've got to tie it to a prohibited ground of discrimination, right? Other than that, the employer can simply say, I understand that that would be more personally convenient for you, I get it, and maybe you're even more efficient if we granted it to you. But this is one of the biggest issues any lawyer faces with a client when you want to settle something. But it does have value, but they often overblow it, but not in this case. The floodgates. You're going to open up the floodgates. If you say, yeah, you can go do that personal, very important item for you, which will help you even be more productive, but then what's the next one? Next employee, the next one, the next one, the next one, the next one. So you're not going to be able to apply it consistently. So you have to say no. Now, subject to unique situations and all that nice stuff. But as a general statement, no. Right? This is our model right now for how we work remotely and how we work back in the office. We expect you to respect it. Right? And that's all there is to it. That's it. Exceptions in unique situations. But you're right to raise that point, because employees will do it. They'll try to find a basis upon which you have to accommodate. And that can be frustrating on the employer side. Trust me. Yeah.
Does the accommodation need to be allowing them to work from home though, or can it be that whenever we have 5 sick days and you're home to look after your kid, or because you say you're not feeling well or whatever, that comes in your sick days, and after that it's not like a blanket work from home?
Yeah, I mean, once again, it's so fact dependent, but think of it as you have no obligation as the employer. Let's assume it's not a prohibited ground, then I don't have to accommodate you, nothing. You want to stay home? You want to stay home and work home? The answer is no. Okay, now what do you want to do? You want to take a day off? Use a vacation day. Do you want to pretend you're sick? Fine, pretend you're sick. Take a sick day, right? But the answer is no. We're not accommodating you for your personal preference as it relates to working remotely on Tuesday. That's it. I'm sorry, we can't do that. And there's no employee, yes, they may feel personally aggrieved. I'm a great employee, I've been there 10 years, look at my contribution, I'm so wonderful. How can you not? But once you explain, look, it's not you. It's about the organization generally. We can't possibly permit this kind of approach to working remotely. that deviates from our policy, because otherwise we're going to have the floodgates. And we can't do that. Yeah?
Well, one question I have is, as we have this discussion, the pendulum seems to swing one way or the other. We're talking about forcing employees back versus leaving employees out. I think for all of us in these industries that we represent, attracting the best and brightest is very difficult, and we're going up against companies like Google. So I think that when we're having these discussions, what we should be looking for is that balance point. Would you agree between?
And that's what we touched on moments ago. The reality of the marketplace is the reality of the marketplace. And as much as we may bang our heads, and where I can say, yes, you have a rightful entitlement as an employer to resist that ask, it may, from a marketplace standpoint, not be the right answer. But that's a business decision. That's a business decision. But I can tell you in our practice and what we do and provide unlimited HR legal support to employers across Canada, we will routinely say to our clients, yeah, sure, you have that right. Go ahead. Yeah, sure. Why are you doing it? Well, because you just told us we have the right. But why are you doing it? You're going to, right? Bite off your nose to spite your face. Because from a business standpoint, and we don't know your business, but we're certainly going to raise the point that from a business standpoint, is it the right decision? Think about it. Think about it. As difficult it is, hold your nose, swallow. Okay, fine. Go ahead. Because you're right. Jason's right. I mean, absolutely right. The reality in the marketplace, as much as, I was going to try to put myself in Generation Z, but you guys would see through me. You guys knew it. So, yes, I think that's a very, in every single situation now, we are in a unique marketplace, and I think you have to cast an eye on that before making decisions that are based on, yes, you're right. Oh, I can't believe I'm about to say that. But is it right? Right? Is it the right move? Okay, so just reading on from our policy, because I know I'm going to get kicked out soon. The music's going to come on, the cane's going to come on. So in terms of selecting who's going to work, right? Suitability of their position for telecommuting, an evaluation of the likelihood of their being successful, an evaluation of the manager's ability to manage remote workers. Because sometimes that's an issue. The manager is just not well suited to it. And yeah, it could, in a sense, compromise the interests of those employees who would otherwise be good, but just got to think about that. And you may have to train the managers, right, to understand what they have to do. But that's time, effort, right? Once again, the decision allowing for telecommuting, sole discretion. They can elect to revoke the privilege whenever they want, right? And professionalism, right, continues to apply. Compensation and work hours, compensation, benefits, work status, and work responsibilities will not change due to telecommuting. Although we had this discussion, Jason and Daniel, last night about the idea of what's happening right now where some employers take the position, well, if I'm going to recruit you, you're from Saskatchewan, and I'm downtown King and Bay, am I paying you the same as I pay somebody at King and Bay? Should I be? Your costs are dramatically less. Now, you know what the employer response to that one is, right? Oh, it's the value of the job. What do you mean you're going to pay me less? Because you recruited me and I live in Saskatchewan. It's the value of the job. What are you saying to me? That's offensive. But pay scales are based in part on where you, right? I mean, we all know if you live in New York.
I think Facebook and some of these companies have addressed that already, right?
Well, they have said no, yeah.
Well, they adjusted based
They
on-
adjusted it.
Yeah.
Yeah, but go.
My son works for Microsoft and he works from home, so they have.
But there are a lot of employees that aren't accepting of that. Particularly, it's one thing when you're hiring somebody and saying, oh, the pay scale now is based on where you are, we recruited you, blah, 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 versus telling somebody currently, I'm reducing your comp. What? And there's the constructive dismissal issue, and then, whoa! And then the whole cultural issue, and the recruitment issue, and the new landscape, and the... That's why alcohol was made available to everyone. And I'll jump over, and there's tools, obviously the equipment, etc. Workspace, okay. The employee shall designate a workspace within the remote work location for placement and installation of equipment. The employee shall maintain this workplace in a safe condition, free from hazards and other dangers to the employee and equipment. It is the employee's responsibility to report any work-related injuries. Now, obtain the appropriate insurance coverage, probably not required in most cases. The company reserves the right to make reasonable visits. Now, to remote work locations to conduct safety inspections in the areas of the remote work location used for business purposes. Most employers will not do that for sort of self-evident reasons. They don't want to intrude on the privacy of somebody's, hi, it's Bill, your manager. Can I go see where you're working?
Can't you put language in there that just says you're responsible, we're not?
You can't. I love that because exactly what you'd want to do, right? What's the limitation? You can't contract out of occupational health and safety obligations. You cannot. Like, can't do it. So you're stuck, employer, with your onerous occupational health and safety obligation, which includes doing assessments, hazard assessments. So how do you do it? No, typically you're not going to go and knock on the door. But you could ask for, please send a video, show me where your workspace is, show me the plugs that are plugged in, show me the exit, right? How you would exit in the event of a fire, or something like that. Show me how the computer equipment is set up, your chair, everything like that. Show me. And let me know if there are any changes. So from an occupational health and safety perspective, the employer's primary obligation is to take every precaution reasonable in the circumstances to protect the worker. All right, so I'm taking that information, evaluating, and see what we do if it's deficient. Yes?
Is the employer obligated to, if it's unsafe, to make it safe? Like, whose job is it to correct the deficiency at home?
Okay, great question. The answer is the employer is ultimately responsible, but, hold it, I'll take you to the next question. Okay, but who pays for it? That's not clear. That, believe it or not, is not clear. Yeah, how does that work? Exactly. It's not clear that the employer has the ultimate obligation to pay for everything because the worker is working remotely in his or her own remote work environment at home. So there's a real question that's still not resolved out there as to that issue. Now, you're going to have to determine in given situations whether you should, 50-50 will cut the, we'll share the cost of something, right? One of the options sometimes that, I'm not sure how great this is, we had this in one of our funny, I called it funny, maybe viewers might not, HR to car videos, is we said, well, buy the chair for the employee, but it's a company chair. So the company owns it, right? That's it. So it's ours. You can use it, go ahead, but it's ours. Okay, so it's a little bit maybe more palatable, right? So, yes?
Couldn't you, if the workplace is not safe, couldn't you ultimately just revoke the work from home, employee that you
Absolutely. If you made the determination, if you're permitting remote work, right, subject to, like this is a policy that we're looking at right now, right? So that policy says you better keep it safe. If you don't keep it safe, sorry, we're not going to let you do that. That's all there is to it. Make it safe, otherwise, no. You're coming back to the office. Nah, that's nice art. Good work. Plaintiffs' counsel, I hate them. They're just, yeah. I mean, look, at the end of the day, it's all going to, once again, depend on the circumstances. But it's certainly if the employer is voluntarily, contributing something to assist. And remember, this is the employee's home environment. Like, you have to take responsibility for your home environment if you're going to work there. So if you don't, I don't see that as a constructive dismissal because it is a condition of working remotely. You haven't satisfied the condition. I didn't breach a fundamental term of your agreement. This is part of the deal to let you work remotely.
But aside from that, what makes the employer an expert in what a home office should be from a safety perspective?
Well, the employer has the obligation regardless, right? From an occupational health and safety standpoint. We actually have a third-party occupational health and safety group that's actually a client, been around forever. They actually go into homes. That's one of the new services they're offering. They go into homes and they do the quick check, right?
They fill out hazard identification and risk assessment form, right?
Yeah,
And that's how the companies track the safety of the work environment.
right.
At home.
At home, yeah. So you're literally doing, that's the idea. So that's a great question, because this third-party occupational health and safety group's been around 45 years. They just started doing that recently because of this very question, right? Okay, opportunity for a new employment agreement. Okay, let's make a deal. What's the deal? You want to work remotely? We have a lousy termination provision in your contract, or you don't even have a contract at all. How are we going to remedy that situation? Here's a new contract. Sorry, your name is? Russ. Russ. There you go. Sign there, please. Russ. And.
I want to see my lawyer.
Yeah. He's gonna see it. So I'm saying to Russ, sign the agreement. If he signs the agreement, I'm going to give him $500. By the way, just pick that number. Russ likes gambling. 500 is his limit, though. So I'll give him $500. It's now got a great termination provision that limits entitlement to minimum standards. So what's Russ saying to me? Well, geez, I've been there for 20 years. Why would I give up my big severance entitlement? My answer in part to Russ is, Russ, are you going to get terminated? You've been around forever, for 20 years. The company's going well. You think you're going to get terminated? For a notional severance, you're not going to take the $500? And I'm giving it to you just before Christmas. And so the idea is, in cutting a deal, so here's the deal. I'll let you work remotely, Russ. I'll let you work remotely. You sign the contract. So instead of $500, I'll let you work remotely. You sign the deal. You don't want to sign the deal, you don't work remotely.
Signed under duress.
Sorry, Russ. Yeah, I put some undue influence on Russ here. But that's the idea. But Russ can say no. He can say no. All right, fine, Russ, you're coming in the office.
Working notice.
That's the deal. Working notice. But that's the idea. So it's an opportunity. When the question back there about legal consideration, that's the legal consideration. I'll let you work remotely. It's a benefit to you. In exchange for that, you sign this new agreement, which I couldn't require you to do otherwise. I couldn't just say to Russ, here's a new agreement, sign it, that's it. And now it incorporates new termination. I can't do that. I have to give him some of value. Otherwise, it wouldn't be enforceable. So the remote work is the thing of value. So you can take the opportunity to make a deal. Right? Okay. Let's get to the expansive. I know we keep touching on it. Employers have expansive, general, specific obligations to maintain a safe workplace under every jurisdiction's health and safety legislation. Ontario has this bizarre provision that nobody trusts. Nobody trusts it. But look what it says for those of you who have workplaces in Ontario. See Section 1 of the Ontario legislation, which provides in part as follows. Private residences. By the way, this has been in the Act forever. This Act does not apply to work performed by the owner or occupant. So it doesn't apply. Or a servant of the owner. Just think about that, eh? Servant of the owner or occupant to, in or about a private residence or the lands and appurtenances used in connection therewith. It seems to say in Ontario, anyways, that the Act doesn't apply for remote work. So you don't have that obligation. Go find one employment and labor lawyer that'll say, I'm feeling good arguing this one. No, nobody feels. Nobody even tries to make the case that this is going to work. But just thought I'd let you know it's there. It's there, right? So the employer's duties include obligations regarding ergonomics. The employer is required to assess ergonomic risks as well as other risks and minimize them. That is your obligation. Now, ministries of labor, are they going into remote works as far as remote work environments? No, they're not doing that. So you're not seeing safety audits of remote work environments. But employees that want to use leverage, that's a whole other issue.
I have a question.
Yes.
It's to do with the termination clause, because, I mean, agreement is nominal and sometimes it's material. And I'm wondering how well in practice it works to try and strip somebody who, let's say
I pegged him at 44, by the way. I pegged him at 44 years. I didn't think it got to 45. 45, right? Okay.
Does that really work in practice? Have we pulled that rabbit out?
Yes. If he voluntarily enters into the deal, the law school, paper chase, a lot of you are old enough for paper chase. I give him an acorn. Russ loves acorns. And I say, Russ, sorry, man, I know I'm a jerk, but I'm not giving you the acorn unless you sign the deal. Russ says, I'll take it. I'll sign it. Give me the acorn. We have a deal. The courts do not typically look into the sufficiency of what's called legal consideration. They won't look into that. The parties made a voluntary deal. He values acorns. The judge may look at it and go, what's wrong with Russ? But anyways, he values an acorn. So Russ signed the deal. So yes, it is. It will be enforceable. You have to make sure there's no coercion, undue influence, and it's voluntary. But if you do that, I'll get to your question in a second. Company of about 250 employees, not all that long ago, we said to them, you will get 80% of the people to sign the first time around. Management long-serving management only got about $1,000, right? And there was a descending scale below management. That's it, and we're talking long-service management. To enter into a new deal with a termination provision limiting entitlement to minimum standards. We told them they would get 80% the first time around. They got 80%. 20% said, no, we think you're going to fire us, and we're going to get screwed. So what did we also tell them? We said a year from now, that 20% is going to come to you and go, is that deal still on? And virtually all of them did. Now, you have to sell it, right? You have to sell it and make it understandable and blah, blah, blah. But if you do it right, if you sell it properly, you can get employee buy-in. And it absolutely does work. So yeah, you can do it. And talk about a mitigation of risk step. It's a huge mitigation of risk step. This is from WorkSafe BC. Since we're here, the employer should ensure it has a basic health and safety policy for working from home. And that each party understands their role, duties, and responsibilities. At minimum, this policy should require employees to conduct an assessment of their workplace and report any hazards to their manager. Right? So this is a BC government publication. An example of some other factors to consider in this policy include protocols for evacuating the home to a safe location if needed, and how to contact the employer in case of emergency. Discussion of safe work practices and how to report any work-related incidents or injuries. Discussion of ergonomic considerations. Yeah?
What about the employee behavior, like abuse, sexual abuse, harassment, this kind of thing? Is the company still responsible for the behavior? Can they monitor? At what point does the clock stop with employees on their own time if they're working from home? Is there a place where the clock goes off and they can yell at the postman if the company's not bound by that? Or, how does that work?
Yeah, actually, I've never heard the question as relates to working remotely and harassing. Like, if you harass a family member, is that, obviously it's not a worker, it's not a coworker, it's not a manager or anything like that. So that's a pretty.
But if we harass the postman that comes to that work, we'd be liable for that.
That's an interesting question, whether the third-party harassment of a third party that's unrelated to the employer could possibly constitute an issue that the employer has. I'm not going to say it's not impossible, because that Canada Post worker, using the example, would probably have to bring a civil action against that employee, name the employer to say the employer was permitting and therefore created this sort of civil wrong. I just got really boring there fast. So I was doing my own musings. But you're right, all the general laws still have application. So let's use the example of that employee on the phone, right? Working remote. Of course that employee, if that employee harasses clients, coworkers on the phone or Zoom or whatever it is, obviously that employee is responsible for that conduct. The employer, typically in harassment situations, if the employer conducts training, then the employee typically won't be liable from the standpoint of having permitted it. If I'm training you, I can't stop you from doing something that you ought not have done. But if I've trained you, how have I not complied with my occupational health and safety obligation as relates to, right? I mean, so that's typically what you would do. And finally, workers' comp. Okay, so what happened with Air Canada? I built this up to make it sound like so incredible. But look what happened. Air Canada employee working from home. She gets up to take her lunch. She was hungry. She was on her break. As she was leaving her office to go to the kitchen, what happened? That was perfect. Whatever that sound was. She tripped on her staircase, injuring herself. Okay. And then she claims workers' comp benefits. So Air Canada's looking at it. What? You're at home going for lunch. And you tripped. What do you mean we have to pay for that? And they're actually sked too, so they actually have to pay for it, Air Canada, right? It's not even paid to the board. The employee claimed she claimed workers' comp based on the injury occurring while exiting the workplace. Air Canada's response, hold it a second. The employee was outside her office. There was no connection to work. She was presumed to be on her private time. Like, hey, we're giving our own employee private time. Like, isn't that a good thing? Now, this is Quebec. I'm from Montreal, so I'll say nothing. The accident occurred during the course of her work and therefore was compensable. Therefore was compensable. So if you're not going to do health and safety hazard assessments and create a greater risk of injury in the workplace, one of the consequences may indeed be this. You're on the hook for workers' comp. And that's my uplifting speech, I think, for today. Just so you know, some self-promotion. As I mentioned, we provide unlimited human resources and employment law support right across Canada for a fixed monthly fee. And we have one-pagers here that you can just take, put in the fireplace, whatever you want. But there's a gas fireplace here, so don't do that here. Okay? That's it. Subject to any questions. Everybody good and depressed? Okay. Well, thank you. Oh, sorry, there's one question.
I was wondering, looking at crystal ball, like you see two things could happen. One is that we have a recession and maybe we go back to an employer's market. And the second question would be, if we don't do that, I'm wondering if we have a gig economy of professionals. So maybe you have somebody at home that's doing accounting for 3 different companies.
I think that's accurate. That second piece I think is accurate. The first piece, what I was mentioning last night in our conversation about this one guy who said it to me, I wish I had coined it, but the current language that describes our current landscape is the Great Resignation, right? We've all seen it, people resigning. It's called the Great Resignation. Tons of articles on it. And this guy said to me, wait, the Great Termination's coming, right? So many do believe a significant recession is coming. And you're going to see that it's going to shift, and a lot of employees are going to be terminated. And so who knows how that pendulum ultimately is going to play out. But if you're looking at it from eyes of people of a certain vintage, you think the pendulum might swing. But if you look at younger eyes, that's the cultural perspective, and I don't know if it gets changed too easily. I don't know. So it is hard. It is difficult to have the crystal ball as to what's going to happen. Reacting now, though, it's a challenging situation. But you're right, but look what's happening with gig workers. You're getting protections, right, out there. There's legislative protections now in Ontario. You certainly have that now. If you work for Uber, you have legislative protection now as it relates to certain terms of your employment. So the government has come in and said, we recognize the gig economy is growing, and we recognize the perceived deficiencies for those that are working in that environment, so we're going to provide protections to them. If that continues, you might see more and more and more, right? Who knows? Who knows? Correct.
Rarely do I see it go to the employers in a call it an equal measure.
Well, I think, and that's where the lobby groups, the associations, right? You get the CFIBs of the world, right? They're out there trying to, at least in theory, promote employer rights, but they don't seem overall to be that successful. And I think there has to be, in terms of promoting the employer agenda, there has to be, I think, a greater concerted effort on behalf of associations. Right? Yeah, it's as though there seems to be a lack of recognition of what it takes to become an employer. it's almost like you're not valued for having done what you did. And so we're not going to acknowledge it. Well, but that doesn't seem to be appropriate. And so, yes, I think you see that challenge, and sometimes there's just the assumption everything will be the way it was, nothing will change, nothing will change. Employers will continue to operate, and you'll have new employers come. Well, no, if you create conditions that frustrate the entrepreneurial development, well, you're going to succeed in frustrating the entrepreneurial development. That's all. Right? So, but yeah, I won't go too far on the political agenda. I get in big trouble. I better stay away from that. Okay, I'm sure I've taken way too much time. So thank you all, and